A defense lawyer in the big Fani RICO case in Georgia admitted that he leaked those photos and videos to the media. Of course, we're talking about Sidney Powell and Jenna Ellis. They took plea deals, and there was certain proffers that were leaked that we covered here. And we were asking ourselves, how did those get out? And do they matter at all? Are they even relevant to other charges? Are they consequential to the Trump prosecution in any way, shape, or form? Well, we could be the judge. People can split hairs on that one. But we know a defense attorney released it, and he said he released it because America needs to know what is actually going on. It's this guy, Jonathan Miller. He's an attorney arriving to courtroom in Fulton County in that photograph, and he represents Mrs. Misty Hampton. And he said in court today, it was me in open court. It was a little bit of a nerve-wracking situation because you didn't know how the judge was going to react. Everybody goes, oh, it was you. And I think everybody was kind of bracing for impact, but we'll have to see what Judge McAfee does. Now, about Miss Hampton and about Jonathan Miller, because we're going to hear him explain this in court in just a minute. He is representing Mrs. Hampton, who is charged with these counts, 32 through 37. And you can see this from this actual charging document, okay? Sidney Catherine Powell, we've already talked about her case a lot here, counts 32 through 37. Look below, Misty Hampton, aka Emily Misty Hayes, same counts, counts 1 and 32 through 37, just like Sidney Powell. And we already know what this set of charges were, okay? It was a contract type of deal. From the indictment itself, it says this was count 32, and this was a whole series of felonies based on just a series of transactions. So the first transaction was a contract. Sidney Powell entered into a contract with Sullivan Strickler, and Misty Hampton aided in the contract, okay? And so she was involved in the contract. They hired this company to go do the thing. They did the thing. They sent him a bill for the thing. They paid the thing. Felony, 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 felony for every one of the things. Now, this is important because what do the other conversations and the other plea proffers have to do with any of that? Anything at all? Not really. And so we're going to jump into the hearing today and try to get our way through it. We already have it queued up past a lot of the introductory stuff, and it's 8 minutes, okay? There was a bunch of different attorneys on this call because this was an emergency hearing. The videos got leaked. Fani says, you're going to wreck our case, okay? Our case, in my opinion, is already, their case is terrible, but they know that, and they say, if these proffers leak, maybe people won't want to take plea deals, or maybe people will recognize that these proffers and what these people are saying don't have any real bearing on our case. I've been hearing from so many people on the left that Fani's saving all of her good stuff for Trump and blah, blah, blah. Well, everything we heard from the media yesterday from Jenna Ellis and Sidney Powell, it adds nothing to the Trump charges at all. And so I think that really Fani doesn't want you to see how weak her case is. Like, people think that the proffers are like all these like damning bits of evidence that are going to obliterate Trump. That's it? We got Jenna Ellis saying that Dan Scavino made some drunk comments to her at a Christmas party. Okay, that's it? So of course Fani wants to tighten this back up so nothing ever gets leaked out. And the defense also wants to, I think, this to be tightened up so that their people can take these smoking plea deals, okay? These are diversion plea deals. Jenna, Sidney, Kenneth, and Scott Hall will have no criminal convictions at all. No guilty pleas. They'll all be torn up and thrown in the shredder. So everybody kind of has an interest in keeping this thing under wraps. The only person who does not is really Donald Trump, who is being prosecuted here. Again, the outcome of this case, I think Fani is going to try to postpone this thing. I'm not sure that Trump is going to actually get to a trial. They're going to want all their eggs in the January 6th basket, and then they'll figure out what to do with this other stuff, okay? This is all just political albatross being hung around his neck. And so this is what it looks like in this particular situation because the videos got leaked. Fani wants a protective order in place. The defense wants a protective order in place so that their guys can keep taking smoking plea deals. Fani doesn't want any actual evidence getting out showing how weak her case is, and we're now showing up with the judge. Is there a consensus between the two sides? Can we get an agreement to have a protective order that requires the defense to go in and watch these videos in the prosecutor's office, or are they prohibited from communicating these things to the public? Can we see more of this or not? This is Judge McAfee picking up on this emergency motions hearing.
Okay, well, thank you for trying to make it work. I will say at the outset here, this is very much just a hearing where if anyone wants to be heard, they can be at it. It was parties may be at. So if you need to run, Mr. Greenberg, I understand that. And as I understand it, it seems like there's been something of a consensus of an opinion forming for the majority of the folks here. So we can dive into that. So I was informed shortly beforehand that I think the state and all but one defense counsel have agreed on the protective order proposed by Mr. Schaefer. And so
He's a co-defendant.
I think that still raises a few issues, though, that we would need to work through, especially since it's not a unanimous on behalf of all the parties. So why don't we start it off with the state? And Mr. Wooten or Mr. Wade, if there's anything that you'd like to address, we can do that. And then I'd have a few follow-ups for you.
Judge, we just moments ago received an email from Mr. Defendant Floyd's counsel indicating that they would agree as well to what the majority of the parties have already agreed to, which is the language in Mr. Schaefer's proposed orders.
Okay.
So it sounds like we're back in alignment. So maybe we're all unanimous.
I'll probably have to do another roll call then and go through everyone again just to make sure that that is the case, just so we have it all on the record. But since I've got you here, and I'll just start this with a few questions of my own. The primary difference here, it seems to be that the state originally had proposed what I would characterize as a blanket umbrella protective order, with just essentially anything and everything that's turned over that wasn't already public or wasn't already part of the defense file was going to be held under seal. Whereas my reading of the Mr. Schaefer's proposed order is that there's going to be this intermediary designation of something's going to be sensitive, and then that's going to be what's not allowed to be turned over. So it's not everything. Is that a fair read of that, Mr. Wade?
It is, Judge.
So what I'm wondering if this is just going to, if it's just going to result in kind of another series of hearings where there are instantly going to be disputes over what's considered sensitive and what's not. So I have to say there was something about the idea of a blanket appeal that I think in a case like this is voluminous and complex and with as many parties that appealed to me. So if you could walk me through where you are and where you've landed on this. I mean, for one thing, I think you'd noted a concern that if parties have the ability to just disclose aspects of their file to the public, I think you'd raise some concerns over that affecting the jury pool. Is that still a concern for yours? And is that going to be adequately addressed by Mr. Schaefer's proposed order?
It is a concern, Judge. It continues to be a concern. But I do think that Mr. Schaefer's proposed order does adequately address it. I think that the posture that we're in now, in terms of walking through Mr. Schaefer's motion, it does indeed address all the concerns that the state has.
It locks everything down.
The court's point is well taken. There could be a series of arguments between counsel as it relates to what is sensitive and what is not, though.
So it's very locked down. The defense might say, well, it's a little too locked down. We want to release that, and we don't know what's sensitive or not. And so the judge is saying, I don't want to have to deal with this order later down the road and try to figure out how to parse through it to deal with a discovery battle. I'd rather just deal with that now.
And Mr. Wade, the state's prepared at this point to go through their entire file and put this label on it and have this done?
We are, Judge. Everything that we've turned over, we believe that we're prepared to go through and say what's sensitive and what's not.
I think you'd indicated, or excuse me, in the proposed order, it indicated simply that what's going to be sensitive is something that should be confidential under applicable law. Can you give us any more guidance of what you anticipate the state labeling as sensitive?
Judge, I can say as one example, and I think this is kind of what brought us here, certainly proffers. Any videos of proffers would be an immediate example of something that would be sensitive. Anything that contains, of course, personal identifying information would be sensitive. Business records that are considered confidential or that would otherwise be protected because of some economic harm if they were to be disclosed would be sensitive. Largely in line, Judge, with what's covered under 1716.4, we believe, with just some additional, 1716.4D, with some additional things that I think just by their very nature make sense to be confidential. Like I said, for example, the proffer videos.
And I think one of the other lingering issues we had to talk about was the state's method of disclosing proffer videos, if any, going forward, going to change as a result of this week's developments.
Yes, Judge, if the court were to enter this order, the proposed order, as it is drafted right now, we would maintain the same system that we've been using, which is we would copy and provide copies of all that information over to the defense. If this order is adopted, it would not change the process other than the procedures that are provided for in the order itself.
Okay, so with that, then let me just go ahead and cycle through again. And
all right, so
no need to add something if you think it's already been addressed, but I want to give everyone, all defense counsel, the ability to have their say, and we'll see if that's still the case on behalf of Mr. Floyd.
Sounds like we got
so
some
from
good
the top,
agreement
Mr.
here.
Sadow, anything that you felt
Mr.
you needed to
Sadow.
add?
No, Your Honor, we are in agreement with the proposed order as described by the state. And of course, it's Mr. Schaefer's proposed order. We've joined in, but we're in agreement.
All right. And for Mr. Giuliani, Mr. Stockton?
Judge, we're in agreement as well.
All right. Mr. Durham on behalf of Mr. Meadows?
We're in agreement, Your Honor.
Ms. Bernard on behalf of Mr. Clark?
Your Honor, our position remains that no protective order is necessary. However, if the court is inclined to enter one, then we do consent to the entry of the one that has been proposed by Mr. Schaefer.
So getting a little bit technical there, the judge will ask.
And why don't you think one is necessary, Ms. Bernard?
The information is largely already publicly available and has been released. And while we are certainly open to considering anything that the state wishes to designate as sensitive materials, the vast majority of discovery discovery in this case consists of information that has been or is being heard in other tribunals on similar allegations. And so we don't think this information that is being released in a number of forums in a number of different ways. And so we don't believe that any of it is necessarily protectable, though, of course, if there is any personally identifying information, as the state has indicated, we're not going to share anything inappropriately.
And because Mr. Schaefer's proposed order has that carve out for everything that's already part of the public record, wouldn't that address your main point there?
And that is why, we're not looking to create a fight over this, Your Honor. And if the court is inclined to enter a protective order, we believe that this one does balance the concerns appropriately by requiring the state to designate what it considers sensitive materials and providing us an opportunity to contest that. I did just want to make sure that our position on the record is that we do not believe a protective order is necessary, given the fact that the information that is relevant to this case and the discovery is almost all information that is of public import, public availability, and public record.
Okay, so 2 tracks are developing now, right? This woman, Catherine Bernard, kind of broke the dam on this. Everybody's kind of, in agreement. Protective order is pretty good. A lot of people on the defense, partition the defense really into 2 kind of categories, and same with the prosecution, really. Like, there are 2 things happening here. There is a criminal prosecution and a criminal defense. That's in one category. And there's a political prosecution and a political defense in another category. And so if you are in the category of exclusively criminal prosecution or exclusively criminal defense, let me say exclusively criminal defense, your position on this gag order, and essentially what this is, a protective order, and the disclosure of any evidence, it's really, inconsequential to you. Okay, you don't really care one way or the other. You care about your butt. It's in the hot seat. You're being prosecuted. Whether this goes public or not is really irrelevant to you if you're going to get a smoke and plea deal, which they're going to get, okay? Because Sidney Powell and Jenna Ellis, 2 people who were on the stages, all got diversion deals where their felonies will be dismissed. Totally. They will have no criminal conviction. So if that's the environment you're in, you're kind of like, all right, we're trying to get a plea deal like that, and you're only trying to save your client's butt. You're not too interested in making political waves, okay? And, causing a scene. All right, let me just go along. My guy's he's innocent, just going to take a plea deal. He'll get diversion. He'll get a couple years probation, be done in 3, he'll be done. That's in, a non-political case like this. But this is a political case, and there is a much, even maybe bigger text, right? The criminal prosecution is actually the subtext of the whole thing. It's actually a political prosecution first and a criminal prosecution second. Now, they would never want you to think that, right? They're always going to tell you, due process and justice of law and all, like what Judge Chutkan says. But we know that's not true. It's a political prosecution first. And so, this woman, Miss Bernard, is communicating that, right? Okay, it's criminal prosecution going on here, but we don't want to be limited by a protective order. We still want to be able to communicate about these things because maybe from the other side, maybe they're not interested in taking a plea deal, okay? And maybe the people who went first actually got the worst deals, because what we're going to learn from them, and the reason why Fani doesn't want these proffers leaked out, is because we're going to know Fani ain't got nothing, man. Her cards, she's bluffing. She's holding up a stack of cards. I got a Sidney Powell conviction. I got a Jenna Ellis conviction. I got a Chesebro conviction. And they got all these like really damning proffers behind the scenes. We're looking at your cards, man. You got nothing. You got nothing. So what they're saying is we want to continue to see these proffers. Yeah, let's put them all out there, because the court of public opinion and the partisan prosecution here will be called out. We'll be able to see that on display, and that may, right, carry over to their clients and to make their clients get better deals. And if not, then we know what evidence Fani has at trial. And so this is where we're starting to see this kind of crack a little bit. And here is what it sounds like.
Okay, well, I'll note your objection and I'll make sure to address that in the order that we enter on this. Okay, over for Mr. Smith. I don't know if Mr. Samuel or Mr. Morris.
We consent to the entry of the order proposed by Mr. Schaefer.
All right, Mr. Nolowitz.
We consent to the entry of the order by Mr. Schaefer.
Okay, and Mr. Gillen, anything you wanted to add generally on behalf of Mr. Schaefer?
No, Your Honor, we consent to the proposal submitted by Mr. Schaefer.
I would hope so. Okay, I think it was Mr. Beaver on behalf of Mr. Still.
Yes, we consent, Your Honor.
We're getting close to
All right,
Mr.
Mr. Floyd, or not Mr. Floyd, but I don't know if it was going to be Mr. Harding or Mr. Kacheroff.
Your Honor, this is Chris Kacheroff for Mr. Floyd. As I indicated to counsel in my previous email, I don't think the protective order is necessary at all. It's not like there's a snitch being revealed in any of these proffers, which is the typical scenario that one would expect to see protective orders entered. But notwithstanding, because of all the defense counsel want to do this protective order, I don't have any objection to entry of this order that Mr. Schaefer has proposed. Only thing I would add is, because it came out in the state's motion that the appearance in the motion was made to seem as though it was the Floyd team that leaked a video. I don't agree, first of all, that there was a leak at all. But secondly, that cost me time and aggravation, because I've had to field phone calls from press relentlessly.
Yeah, Fani's
asking
office.
why Floyd leaked the video. And they got it And I asked them where they got this information from, and the universal response was, well, the state put it in there. They put your email in the motion. Well, the state didn't put the other email in the motion, which was that we had made a typo. Mr. Harding had originally said we are the source of the leak. He meant to say we are not the source of the leak.
Oh, not.
And so they played upon that, and that, frankly, is irrelevant to the motion, but it cost me aggravation. So I just wanted something on the record from the state, just acknowledging we weren't the ones that were doing it.
Well, I don't know if the state's in a position where they can actually say definitively who did or did not. If I recall from their emergency motion, they noted that you later acknowledged it was a typo. I don't know why the need for the email attachments, but here we are. And I think we've all, when we signed up for the case, agreed for some level of aggravation, but here we are. I think, was there anything else though, other than the note there, that you think we need to address as it relates to the terms, exact terms of this protective order?
No, Your Honor.
Okay. All right. Thank you, Mr. Kasharoff. Or is it Mr. Cromwell on behalf of Ms. Latham?
Yes, Your Honor, and we consent to the proposed order by Mr. Schaefer.
We're getting close, working our way through the co-defendants.
Mr. Miller, on behalf of, excuse me, Ms. Hampton.
Here we go.
Judge, if I may, Ms. Hampton does not believe that an order is necessary, that this is one of the biggest cases the country has had.
True.
And that transparency is very important.
True.
Since I've been working with her for the last 2 years, she has always said that she wanted to be 100% transparent. And that is why we are opposed to having any kind of regulations on what we can expose and what we can't. But with that in mind, we will adhere to any court order that the court does, and will do so with diligence. But Judge, in being transparent with the court and to make sure that nobody else gets blamed for what happened, and so that I can go to sleep well tonight, Judge, I did release those videos to one outlet, and on all candor to the court, I need the court to know that.
Well, I appreciate that, candor, Mr. Miller. Is there anything else, though, you'd want to add in terms of, I suppose I would lodge it as an objection to the protective order, but not a vigorous one, I suppose. Is there anything else you'd want to add, though, your thinking behind?
Thanks for telling me, but I didn't
why
even
you
know
felt
that.
these proffers needed to be part of the public record? Because it feels like that should be part of the analysis that I had to do of justifying a protective order.
If the court will entertain me, Judge, all four of those people that did their proffers, they stood in front of you, they did their plea, it was all recorded, it was sent out there for the world to see.
We watched it, covered
And
them.
to put those proffers, hide those proffers that show all the underlying things that went into those pleas,
which was nothing,
it misleads the public about what's going on. I don't believe that two of those defendants were directly related to my client, and I don't believe that either one of those hurt my client. If anything, I believe they helped my client. And the public needs to know that.
He laughs.
So please keep that in consideration in any order that you do.
And Mr. Miller, how would your ability to eventually get that in front of the public at a trial be foreclosed by a protective order saying this shouldn't come out until it's determined to be admissible and it should come out at the trial?
It's a political prosecution.
Judge, the problem with that is that this is a very, very public trial. We all know that. How many newspaper organizations are out there right now looking at it? That allows the DA's office to set the tone for the entire trial.
We got
without
convictions.
giving consideration to the other side of the coin. And that's what needs protecting, Judge. And the public has a right to know.
We do. And we were here screaming from the rooftops, okay, that the Fani plea deals for Sydney and Jenna were jokes, were total jokes, because they're diversion deals. They're going to be dismissed. All of their charges are going to be dismissed. The guilty pleas that they took was a guilty plea proceeding. The judgment was not entered. The court did not accept a guilty plea. We read the documents here, but the media and Fani and everybody was saying, these were smoking deals because behind the scenes, they got what they needed. Behind the scenes, they're going to come after Trump, and Trump's done for. I saw these lefty lawyers out there saying, well, this is just being done, so that they can aggregate the claims and then prosecute Trump. It's all about the big fish, and these are all little peons. What are you talking about? It was Jenna Ellis and Sidney Powell. The only other person was Rudy Giuliani up there with them. Come on now. So the fact that the proffers showed like nothing, and this defense attorney's like, they don't even hurt my clients at all. They help my clients. They're saying that Jenna and Sydney are going to incriminate my client. They're not at all. And we should be able to have that out there because there are two tracks here. It's not only the criminal prosecution in your court, it's also the court of public opinion. And we've got an election coming up, and we can't have this facade being played out that Trump and all of these people are really criminals and insurrection. They're not. They got smoking deals, and there's no evidence.
Well, it's a good slogan, but do we have any case law that says pretrial discovery is a part of our First Amendment concerns? I know Mr. Clyde is sitting there just waiting to be teed up here on behalf of the media organization, but it seems like having open files for everyone to start litigating the case before we actually get inside of a courtroom comes with a lot of side effects. I don't know if we've thought through.
Judge, I cannot argue with that logic. But so far as case law on these issues, I can quote you a couple of things, but note that the state's only case case law that they came up with was a case that wasn't even related to Georgia from 1993. There's just not a lot of Georgia law on this particular issue.
Yeah.
No, I'll certainly grant you that. I think we're a bit unmoored here in Georgia on this issue, but I'll put all those thoughts in the order, which I will hope to get out by tomorrow morning. All right, Mr. Miller, if there's anything else you want to add, if not, I will move it on to Mr. Greenberg. Anything else, Mr. Miller?
No, Your Honor, I appreciate your time.
All right, Mr. Greenberg, if you're still with us.
Yep, I am, Judge. I got a better connection now. So we don't have any objection to the order. However, there was one issue that did come up, which was a suggestion that we would have to travel to the district attorney's office to view video interviews and so forth. Obviously, those are going to be key to trial. They're going to be the kinds of things that you're going to need to work with. So I'm hoping when they designate things as sensitive, they'll take into account the representations of people here today and that we're all professionals. And I'm looking at the screen, and while I don't know most of the people, it looks like almost everyone's been around a while and should be able to be trusted to act in a professional manner. We won't have to encamp in Atlanta in their office to look at discovery excessively.
Well, Mr. Greenberg, if I interpreted Mr. Wade correctly, I believe they withdrew that notion. And so whether designated sensitive or not sensitive, discovery is going to go back to the regular course of things. Did I capture that accurately, Mr. Wade? All right, I'm getting a general nod, and there we go.
That might have been while I was searching for a signal, Judge, because I had to switch from the 20th floor to the second floor.
Okay, understood.
Thank
All right.
you.
And so finally, I think we have on behalf of several media organizations, Mr. Clyde.
Okay, we'll listen to a little bit of the Mr. Clyde.
Thank you, Your Honor. As I mentioned, I'm here on behalf of the Atlanta Journal-Constitution and WSB-TV, but also the Associated Press, CNN, Gray Media, Tegna, Scripps, and the Washington Post. We do object to the entry of the protective order. It is a vigorous objection, Your Honor. And first, I'm going to address the need for the protective order, and then I'll speak to the terms of the protective order. First, Your Honor, we would submit there's just not a need for the protective order to be entered at all. The state in its motion, the defendants in their motions have basically referred to OCGA 17-16-4D. But that authorizes the court to enter a protective order only upon a sufficient showing that discovery required by that article would create a substantial threat of physical or economic harm to a witness. That just hasn't been shown, and that threshold hasn't been met.
Sorry,
and it may be
no order.
that both the state and many of the defendants now consent to some form of a protective order, but that has not been authorized essentially by the law. Essentially, what the state and the defendants are trying to do is get the authority of the court behind an order that will impose secrecy on information that's exchanged during the discovery process, notwithstanding how newsworthy that information is, notwithstanding how much it might inform the public about the circumstances of this case, but particularly in this case, the circumstances of an election that took place that's of extremely significant public importance.
Exactly right, because again, there are those two tracks, right? Even the defendants might have an interest in kind of covering this whole thing up, okay? Because Sydney and Jenna, and I know, right, it's easy to dunk on them, and you got to go to trial. How dare you take a guilty plea for something you didn't do? And I get all of that, okay? I get it. And I've represented many people who had that same opinion, and what ends up happening is oftentimes those people lose at trial. They go to jail, and it's maybe a wise decision to attempt it, maybe not. Sometimes you do win, but in a politicized prosecution like this, where, you know, kind of writing is on the wall, you take a plea deal sometimes if it's going to be a smoking plea deal that is not going to be a guilty conviction, okay? So like, I know like temporarily entered a guilty plea proceeding and the court has held this whole thing in abeyance, but it's going to go away. So you can really justify that, right? The analogy is like defensive driving school or something. You just, I did it. It's not worth the hassle. I'll take the deal. It'll all go away later. But what about the public? What about that second path here? We don't want these people covering this stuff up. We don't want the Fani to bury all of these proffers under the dark of night and then have them run around saying that Jenna Ellis and Sidney Powell have dished the goods on Trump when they haven't. We've got a whole election where that information would be very useful to show that, yeah, maybe they went through these proceedings, but it was on something that is not consequential, right? The implication is that Trump is guilty, and the proffer show, not really.
So, Your Honor, it's not a matter of whether both sides agree. It's a matter of whether the standard has been met, and we would submit the showing is clearly insufficient to meet that standard.
All right, and so they carry on, and they go on for quite some time. The judge ultimately takes this whole thing under advisement and is going to issue an order at a later date and time. And so, my friends, of course, we will be here continuing to cover the RICO case, and as soon as the judge issues an order, we'll cover it. We'll see if they are going to be issuing a protective order that stops any more plea proffers from coming out. I'd like to see them personally. I think it'd be very useful to see if they actually have any evidence. I've long suspected that they do not. And we also know that in another video here, which I really recommend you watch, a federal judge out of Georgia, out of the Northern District of Georgia, called Amy Totenberg, said that there was monstrous election problems and deficiencies in Georgia stemming all the way back to 2018. So with that juxtaposed with these weak proffers, juxtaposed with these weak plea deals, Fani has no case. Her case stinks. And so we'll be here continuing to cover this, my friends. I'd love it if you joined us as we do by hitting that subscribe button. Would very much appreciate a share of this content so that other people can see what's actually happening here and join us as we break it all down, because they are trying to create a narrative that just simply doesn't exist. Fani's case is garbage, and we're going to be here continuing to expose it. Thank you for joining us as we do. Thank you for checking out robertgovea.com to sign up for our daily newsletter, and we'll be looking forward to seeing you on the next one.